Welcome to the Prison Professors Podcast. We serve people who face challenges with prosecution, sentencing, and prison. My co-founders are Sean Hopwood and Justin Paperny. My name is Michael Santos. We create digital content and our team offers individual consulting services. We also assist agencies that want to improve outcomes. To learn how we can help you, text the word PrisonPro to 44222. Again, text PrisonPro to 44222 and get our free brochure. You can also visit us at prisonprofessors.com or contact Justin at 818-424-2220. Please subscribe to our podcast on iTunes. Send confirmation that you reviewed our podcast and we'll send you a free digital book. Stay tuned for a 20 to 30-minute episode of Prison Professors. Welcome to Prison Professors. I am Michael Santos, and part of our mission to help people who are going into the criminal justice system or people who are in the criminal justice system is to feature distinguished community leaders. And today we have the privilege of meeting David Rosenfield, who is a partner at the distinguished New York law firm of Herrick Feinstein, and he's got a lot of experience that I think can help anybody who is going inside. Why don't we start, David, by first of all me thanking you and welcoming you to our program, but perhaps you can give our audience a little bit about your background.
Well, thanks, Michael. It's a pleasure to be here, and I'm happy to join in our conversation. In terms of my background, I was at the Securities and Exchange Commission going back some 25 years or so, and I was there a short period of time. I worked on a significant market manipulation case. Then I moved to the U.S. Attorney's Office in New Jersey, and I worked on primarily securities fraud cases, market manipulation, fraud in terms of people being given false information about offerings, and I also did a bank fraud case. Then I moved to the Bank of New York, and at the Bank of New York, I did internal investigations. I was head of the anti-money laundering group in terms of providing legal assistance to that group. And I've been at Herrick Feinstein since 2004 doing white-collar defense, primarily securities fraud and bank fraud. I recently did a sanctions case, all kinds of cases, obstruction of justice cases, lying to federal agents, kind of a broad stretch of different types of cases since I've been at Herrick.
So a real depth and breadth of experience that will be of benefit to anybody, particularly your experience with the U.S. Attorney's Office. I think that would be really valuable to learn a little bit more about the prosecutorial process. And maybe you could tell our audience a little bit about what an individual should do if he learns that he has become a target of a criminal investigation.
Well, let me tell you first what I think a person should not do, and that is I don't think that the potential target should reach out personally to the government prosecutors or agents. I think what's important for the target to do is to retain an experienced white-collar defense attorney. If it's a securities case, you want someone who's knowledgeable about securities law. The same thing if it's a bank regulatory case, someone who's knowledgeable about bank regulatory matters. But the most important thing, particularly if it's a criminal case, is you want an experienced white-collar defense attorney. That's who you should hire.
And when the person finds out that he could potentially be a target of an investigation and he starts working with or hiring a defense attorney, how does he go about determining, well, how do I know if a defense attorney specializes in the type of practice that I need? You just differentiated between a securities type of a crime and another type of crime. What questions might a defendant ask to make sure he's making a good decision with regard to hiring counsel?
Well, instead of asking questions, what I would do is a Google search on the attorney. You want to find out what articles they prepared. What does their biography say? And you want to talk to them as well to find out about their background. But I wouldn't just rely on asking them what they do. A Google search will tell you everything you need to know about that attorney to make sure that attorney has the experience that you need in the case that is being brought or potentially brought against you.
When the Assistant U.S. Attorney is making a decision to bring charges against a defendant, could you help our audience understand a little bit about what level of discretion he has with regard to how he charges somebody?
The level of discretion of the Assistant U.S. Attorney is broad but not absolute. So what the assistant U.S. attorneys do, they work closely with the agents, and often it's going to be with FBI agents, but it could be with agents from different agencies, Health and Human Services, for example, or the SEC has agents, but usually it's with FBI agents. They'll work very closely with the case agent to study the case, understand the case. They will review the documents, all the pertinent documents. They'll send out subpoenas, grand jury subpoenas, to get the documents that they need. And then they'll review everything, and then they'll make a decision as to which way they want to go in terms of charging the case. They work with supervisors. The U.S. Attorney's Office it has a lot of levels. You have the assistant U.S. attorneys, who are also known as the line assistants. They have supervisors. The supervisors usually have supervisors all the way up to the U.S. attorney. There's a back and forth between the line assistant and the supervisor, and the line assistant will usually draft the indictment. The indictment will always be reviewed and changed as necessary by the supervisor. It will go all the way up to often the U.S. attorney to actually sign off on the indictment. So while the assistant U.S. attorneys have a fair amount of discretion, and what they decide to do is generally backed by their supervisors and the U.S. attorney, it's by no means complete, and it is subject to, what they do is subject to several levels of review.
Are there steps that a defendant can take, together, of course, with the guidance of counsel, to influence that process? So whereas if he doesn't do anything, maybe he might be charged one way, but if he takes some proactive steps, he may be able to influence that charge.
Sure. The first thing is a decision as to whether or not to cooperate. If the target decides to cooperate, comes in early, and maybe is even the first person in the door, that person may not be charged at all. I had one securities fraud case. It was a market manipulation case. The first person in the door essentially got a pass. We decided not to charge that person because they came in right away, they fully cooperated, they disclosed what they knew, and so we gave them a pass in the sense of they weren't going to be prosecuted, but they had to fully cooperate. If you come in a little later, chances are you may have to take a hit or be charged with something, but you still fully cooperate, and then the charges are generally reduced, and you face less jail time. And in general, it's a much better situation if you come in and cooperate. Now, there's other things that you can proactively do. Let's say you're not going to cooperate for whatever reason, and you feel that the assistant U.S. attorney and the agents are not being reasonable. What you can do, and when I say you, I'm really talking about your white-collar attorney. What your white-collar attorney can do is go over the heads of the agents and the line assistants to the supervisor or all the way to the U.S. attorney and say, look, what they're doing here is just not right. I wanted to make you aware of what's going on. The problem with that is that inevitably, and in most cases, the supervisors and the U.S. attorney himself or herself is going to back the line assistant. So I rarely use that technique. I only do it if I think the assistants are being completely unreasonable and I feel I have no alternative. So those are the kinds of things that you can do to try and have the case framed in a light most favorable to your client or to yourself. You have options. And then, of course, the most important thing is cooperation. If you're in a position to do that, that's the best way you can frame it in the most positive light for yourself.
On the Department of Justice's website right now, there is a memorandum that I think has been referred to as the Sessions Memorandum, which changes the way the U.S. Attorney General is directing prosecutors to bring cases. He's arguing that they should bring the severest charge that they can potentially prove. Is this a different type of a directive than happened in previous administrations, perhaps maybe when you were a U.S. attorney?
Yes, absolutely. We never were told to bring only the most serious charges possible. We were told to consider all the possibilities and bring what we thought were the most appropriate charges, not necessarily the most serious charges. So this is definitely a change in philosophy. It's different than when I was there. Now, different districts operate differently. Some districts, have for a long time brought the more serious charges. One that comes to mind is the Southern District of New York. They bring very serious charges. You've read about their insider trading cases and other cases, similar cases where they brought very serious charges, and people have received extremely high sentences following conviction. But the whole idea of the Sessions memo, where they're not giving them much discretion and simply saying, go for all you can get, is different. And frankly, I think is not the right way to go. I think that line assistants and agents should have the ability to consider what's an appropriate charge to give, and not necessarily the most serious, but because you got so many different things to think about. The background of the people, the charges involved, the victims involved, the amount of money involved. There's so many different things to take into consideration that you don't always want to bring the most serious charges. So I don't think that's a good trend, frankly.
I would agree with you. I do think it's important for defendants who are facing these kinds of charges to understand the landscape and the playing field that they're going into. It is a fundamentally different playing field from what existed when you were a U.S. attorney and you had more maybe the use of wisdom and tempering justice rather than going after the most severe type of offense, which has led to, of course, our nation's massive prison population where cases are coming that perhaps could be solved in civil courts, but are now all resolved in the criminal courts.
I think it's very important for the targets of the defendants to understand the landscape has changed under Sessions and that they can expect more serious charges, likely more serious sentences. That doesn't mean that in certain cases you can't discuss, you being, again, your attorney, can't discuss with the prosecutors and the agents what you think is an appropriate disposition, not necessarily the most serious. And from what I know, the Sessions memo is not saying it must be the most serious charge in every single case with no exceptions. There are always exceptions. And that's where your experienced white-collar attorney comes into play and can be most effective by discussing with the assistant U.S. attorneys and the agents a proper disposition, which is not necessarily the most severe charges, and in most cases won't be. And I think that many assistants, their supervisors, and on up to the U.S. attorneys will be open to at least considering charges that are not the most serious charges possible.
All the reason for somebody who is or facing a charge with the criminal justice system to seek the best possible counsel with extensive experience, both a depth and breadth of experience. David told us to do a good Google search to begin, but also just do your own research and figure out as much as you possibly can about the landscape, about the system, about sentences that are being imposed. And when you're speaking with counsel, of course, be completely honest and talk about your exact involvement so your defense attorney can give you really good guidance. David?
Yeah, and Michael, that's something that I actually recently did a blog on. The whole idea of cooperating with your own counsel seems inherently that there's no question that that's what you're going to do. But that's not what happens. In virtually every case that I've been involved in, it's a process for the client to come clean, if you will, with their attorney and tell them everything that they've done wrong. They tend to minimize. They're worried about their reputation, about what their attorney may think of them, what embarrassment, whatever it is. So they tend to minimize. And my recommendation is come clean. Come completely clean as quickly as you can with your attorney. That's the only way your attorney can give the most effective defense that you need and that you deserve.
Without a doubt. And I would agree that many white-collar defendants or business people in general that face a case, ordinarily, they're entrepreneurs, they're risk takers, they believe that they can overcome an obstacle. But fighting the U.S. government is an obstacle of an entirely different nature, and you really need a great quarterback, and that's what your white-collar defense attorney or your defense attorney is supposed to be for you, the quarterback that's going to make the best possible decisions, giving those circumstances. I'll tell you, I interviewed another former U.S. attorney who's now in the defense practice, and he said that when he was an assistant U.S. attorney, he won 100% of his cases, and he really thought of himself as the most brilliant U.S. attorney prosecutor, and then he switched sides and went to the defense side and didn't have quite that same level of success. Realized that maybe the playing field isn't quite as level as he had thought when he was prosecuting. Did you have any experiences like that?
Sure, I absolutely did. In fact, we just completed a trial about 3 weeks ago where the result wasn't as good as we had hoped, and our client was convicted. We certainly think there's many issues on appeal, but it's very difficult when you're defending a defendant in a criminal case as opposed to being a prosecutor. The conviction rate is up in the 90s somewhere of people who actually go to trial, and very few cases go to trial. Most are disposed of via a plea. But even the people that decide to go to trial, and those are the cases generally where they're the weaker cases and there's more likely of a prospect for the defendant to win, the defendant still almost always loses. I can definitely speak from experience. So, and most of my other cases have pled out, actually.
And it's important for a defendant to understand why. I mean, if a person goes to trial, it's going to be a jury of peers, but that jury is going to be made up of nurses and teachers and firemen and people who have never seen the United States of America versus the last name, and that can certainly begin some judicial bias, not only from the judge, but from the jurors and everybody, because when you see that, it's just like reading something in the newspaper that somebody's been accused of a crime. Immediately, the thought is conviction. And that disposition is important for a defendant to recognize that when he is going into the criminal justice proceeding, he's got to be honest with counsel, and he's got to understand, I am already at a significant disadvantage, and now I need to start managing best outcomes. But you brought up a trial. Oh, did you have something to say?
Well, I was just going to say, and the trial I just had was the defendant was a foreign defendant, which is even harder.
Right.
In terms of what you just said, as the American flag and the prosecutors and so on. When it's a foreign defendant, it's even harder.
And so we've got to take all of these factors into consideration, which is one of the reasons we try to give away as much information as we can, bring on experts like David Rosenfield from Herrick and Feinstein, a prominent white-collar defense law firm in New York City. But David, you mentioned a trial. When there is a conviction that doesn't come from a guilty plea, that goes through a trial, tell us a little bit about what a defendant should expect with regard to the sentencing process for somebody who was convicted at trial. How is it going to be different from somebody who pleaded out?
Sure. The sentencing guidelines are still in effect. They used to be mandatory. It's a point system where you try and figure out what a sentencing range will be. And it used to be mandatory, and then in the U.S. v. Booker case, which was 2004 or 2005, the Supreme Court ruled it was unconstitutional for the sentencing guidelines to be mandatory. However, judges are still required to consider the sentencing guidelines. And in fact, virtually every judge I've been in front of uses the sentencing guidelines. So I don't think things have changed a lot since Booker. So what happens is you add up all these points that you put together for different areas. Like, for example, if you're a leader of a conspiracy or a scheme, you get 3 or 4 points added and things like that. If you accept responsibility by pleading guilty before trial, you get 2 points taken off. If you plead guilty in advance of trial enough that you save judicial and prosecutorial resources, you take another point off. So you have 3 points taken off for a guilty plea, and that goes into your sentencing range. It will reduce your sentencing range under the guidelines. So by not going to trial, you will save those 3 points and get a lower guidelines range. Now, if you go to trial, the other problem is the judge sees all the evidence that comes in against your client. And that could predispose the judge to giving a higher sentence by seeing things and evidence that the judge would not have seen if the person had pled guilty. So you can, and the maximum sentences now, and again, the guidelines are only advisory, they're not mandatory. The maximum sentences can range up to 30 years. For securities fraud, bank fraud can be up to 30 years. Wire fraud, mail fraud can be up to 20 years. They're very extensive sentences, but still, what most judges do is they will sentence within the guidelines range, but expect a much higher sentence if you go to trial and you lose than if you plead guilty ahead of trial. And the other thing to keep in mind for defendants is if you take the stand at your trial and you lose, then a perjury application could be added, and that will also increase your guidelines range and thus your sentence. So there's a lot of risks to going to trial.
You spoke about the possibilities of going in excess of the guidelines. We know that there's also a possibility for downward departures. A judge may go beneath the guidelines. Could you tell our audience a little bit about some steps that you have made, that you may have seen, both in your capacity as a former AUSA and as a defense attorney, that a defendant may take that may move the needle toward a downward departure, possibly even with the support of the U.S. attorney? What steps could somebody take to position himself for that?
Well, a downward departure, by the way, is generally only granted if there's what's called the 5K motion or letter from the government asking that the judge sentence below the minimum guidelines range. So that you want the government to push for a sentence below the guidelines range. There's lots of ways that you can fully cooperate, and that's the only way you're going to get the government to file a 5K letter is if you fully and substantially cooperate. That could involve taping a phone call. That could involve wearing a wire. That could involve sitting down with prosecutors and agents and unraveling a complex scheme, explaining that complex scheme to the government so that they understand it. In many cases, they don't understand everything that's going on, especially if it's an esoteric or very, unusual statute that's being prosecuted. If you testify in front of the grand jury, if you testify at trial, all of those things are ways that will lead to the government to conclude that you have substantially cooperated and will lead to the government giving a 5K letter. Judges look very favorably on 5K letters. That's almost always the time that a judge will go below the guidelines is if there's a 5K letter from the government saying the defendant has substantially cooperated and we, the government, Your Honor, ask that the defendant be sentenced below the guidelines range.
So could you give us some, using both cooperation as an example and perhaps individuals who didn't cooperate but pleaded guilty, what would be some best practices for sentence mitigation for a defendant to be thinking about so that he can really strengthen his defense attorney's hand, that when the sentencing time comes, the defense attorney has all of the tools in his arsenal to argue for the best possible outcome?
Well, the most important thing is cooperation. And when I say cooperation, I mean cooperation early and often. Be the first in the door, give substantial cooperation, don't hold back on anything, do whatever the government tells you to do that's appropriate, testify against your co-defendants. I've had clients who've worn wires and taped friends of theirs. Those are the kinds of things that you need to do. It almost all revolves around cooperation to get the best possible sentence that you can get. And again, in terms of cooperation, don't wait till the end. The government may not need you at the end. And the government may give you a window right up front and say, look, you got 2 weeks to come in, or any kind of appropriate plea disposition that they may be offering is off the table. So you want to get in early, you want to fully cooperate. That's your best bet at sentence mitigation. By far, there's nothing else even close.
So certainly that is the best bet. But tell us about, you'd mentioned earlier that if a defendant chooses to plead guilty versus going to trial, that defendant may shield some information to getting to the judge that the judge otherwise would have considered. How about a defendant who takes some proactive steps to reflect his character, that this was an aberrant, perhaps aberrant behavior,
Sure.
that this is he has other mitigating factors in his life, but he does this in a first-person way. Have you ever used that strategy or approach in sentencing where a defendant is really making a first-person case that of the type of person that he really is, and that this was just an aberrant decision?
Absolutely. I've had a number of cases where this is kind of a one-off situation. The person did something that was improper, but was completely out of character. And we emphasize to the court that this is aberrational conduct, that we emphasize that the background of the person is such that they haven't committed other crimes. They're not going to commit crimes anymore. They've learned their lesson. We will file letters from friends, from relatives, from coworkers, indicating what the type of person that they are, that they're a positive influence in the community. So aberrational conduct is something that we absolutely stress. And I've had a number of clients where their cases I truly felt were aberrational. If it's not aberrational, then you've got some problems and some issues, because the judge wants to know, why are you back in front of me? Didn't you learn your lesson? So absolutely, I stress the aberrational circumstances if that's appropriate.
So we've talked about best practices. How about some situations where defendants may have complicated your efforts at sentencing by doing something or not doing something that they should have done to help you get them the best possible outcome?
Well, first of all, what happens in virtually every case for me, and I think for most defense lawyers, is that the clients are not completely upfront with us right away, and that delays any potential cooperation that they may give. It's a process, and we run into that all the time. But I can give you one example of a case where there was a problem between me and my client. When a client is sentenced, I will always go over what the client is going to say in court to the judge. The client's allowed to speak to the judge at sentencing, as is his attorney and as is the government. So what I always do is I work with the client to literally write out a statement as to what the client is going to say to the judge. Contrition is important, remorsefulness, I won't do it again, I've learned my lesson, that sort of thing. We write it down so that they can refer to it. If they get nervous, whatever, it's right there in front of them. In one case, I had a client who said, you know what, I'm going to do this off the cuff. I don't want to prepare anything. I want to speak from the heart. Against, I guess, my better judgment, I let him do that. And it did not work out well. He didn't come across as remorseful. It wasn't well prepared. The judge was not impressed by it. And I think we clearly did not get the sentencing result that we would have gotten had he prepared something in advance that I had carefully reviewed with him. So that's one lesson I learned, is do not allow your client to speak off the cuff at sentencing without being fully prepared, without having a written statement already done and ready to go for the judge. So I would never let that happen again, no matter how hard the defendant pressed. You have to have it the statement ready to go. The judge is looking at that defendant and wants that defendant to express remorse and say, I'm sorry, it's not going to happen again. And if the defendant doesn't do that, the judge is going to have every incentive to institute a higher sentence than he otherwise would have.
Certainly every defendant is hoping that they can get the types of outcomes that you get for your clients, David. What if, when people get a conviction, though, what types of collateral consequences should they anticipate after the judge says, I hereby sentence you to the custody of the Attorney General?
Well, it's funny you should say that, Michael. I have in front of me a judgment of conviction, and I can tell you just from looking at this, some of the things that people have to understand what a conviction means. First of all, you're going to have supervised release. And supervised release means you're under the guise of a probation officer. It's 2 years, 3 years. Those are generally the standard conditions. There are a number of mandatory conditions. You can't use or unlawfully possess a controlled substance, for example. You have to make restitution. You must cooperate in the collection of DNA. Those are the kind of mandatory conditions. And then let me tell you about the standard conditions, because those are really detailed and important to know. You have to report to your probation officer in the district where you reside within 72 hours after you're released from prison. You have to continue to report to the probation officer as instructed. You can't leave the federal judicial district where you're living without the approval of your probation officer and or the court. You have to live at a place that's approved by the probation officer. You have to allow the probation officer to visit you at any time. You have to work full-time. If you're not going to work full-time, you have to have permission from the probation officer. You can't interact with someone who's committing a crime. If you want to consort or meet with a convicted felon, you can't do it unless your probation officer says it's okay, and on and on and on. Those are the kinds of things that you, as a convicted felon, have to be prepared for. You can't carry a firearm, for example. There's lots of things that you have to be prepared for if you're a convicted felon, but the most detailed set of circumstances are dealing with and reporting to your probation officer. And again, this is over a 2 or 3 year period, and if you violate parole, you're going right back to prison.
That's the important message. Those collateral consequences that David just mentioned can result in an additional term of imprisonment. And that applies to any individual who's convicted of a federal crime. But there are additional collateral consequences that may include where you can live when you fill out an application to rent a condominium or an apartment, that may include where you bank, that may include your access to credit, that may include, of course, your access into the employment market and into various professions. So there are a number of collateral consequences that influence the life of every individual who has a felony. And again, that is the reason that we encourage people to find great counsel like David, who takes a great interest in his clients and helps them get ready for the journey ahead, understanding that you're going to have to lose some battles in this war, but there is a pathway through. And we're just very grateful to you, David, for taking this time out of your busy day as a New York City attorney to speak with us. And we encourage any white-collar defendant who is in need of counsel, whether you're in the Southern District of New York or anywhere else, reach out to David. We're going to have a link to his website on the show notes for our program. And again, I just want to thank you personally for taking this time to speak with us, David. Do you have any final words that you might want to share that I didn't cover in this interview?
No, Michael, well, thank you very much for having me. I really appreciate it. I would just say it's a long and arduous process, whether you're going to plead and cooperate or whether you're going to go to trial. You have to take it step by step. And you need to count on your criminal defense lawyer to guide you through. And that's why it's so important to retain an experienced white-collar defense lawyer who knows what they're doing, who can get you through the situation. It's very, very hard on people. We understand that. We've been through it. And so you need to trust us and count on us to help you through it.
Thank you very much for sharing your important message. If you would like show notes, please visit us at prisonprofessors.com or whitecollaradvice.com. And if you want more information on the ways that we try to help people who are going through the journey, text the word PrisonPro to 44222. Thank you very much. We'll be back tomorrow with another inspiring guest. Thank you.